Welcome to today's John's Briefs, here with Mark Victor from Attorneys for Freedom. And on John's Briefs today, we have one that I see all the time in South America. Had it recently on the channel. We'll put a link in the description and a card and all that for here in the U.S., in Houston. And it was a subway robbery. Dude pulls a gun, waves it around a little bit, threatens with the gun, then puts it away. What I want to talk with you, Mark, about is on this issue of the use of deadly force to defend myself and imminence with respect to stuff like this. Today's video is brought to us by the generosity of Firearms Legal Protection. Firearms Legal Protection is a legal defense program for lawful gun owners. You win the fight, and they will help you win the fight after the fight for the rest of your life. There's a link in the description for a coupon code for a discount for all active self-protection watchers. So Mark, I know the general rule is I'm allowed to use deadly force to protect myself from the, whether we call it imminent or immediate, depends on the words, threat of death or great bodily harm. That's when I can use deadly force to defend myself. How do you think it applies to something like this where the guy has put the gun back away?
Yeah, I think it depends on the context, like everything else. And in the context of this video, this guy's in the midst of a robbery.
Yeah.
He's in the midst of an armed robbery. In armed robberies, I think it's fairly common that guns come out, people get shot. It's a horrible situation. So it's very hard to predict what a jury might do with it or what even a prosecutor might think of it. But I got to tell you, to me, even after that guy puts it back into his waistband and he's still getting the money, I think if somebody shoots him at that point, I think we're okay on imminency because I think it's still part of the same transaction. On the other hand, if he turns around and now he's exiting the door and now you shoot the guy, then I think you got a problem because now you're really protecting property. And then the argument's going to come in, well, the reason you shot was to protect property. The reason you shot was this guy has a gun and he pulled it out already once on me and I'm afraid he's going to shoot me and it only takes a second for him to pull it out. I watched him, it came out pretty quick and he put it back. I think that's pretty imminent. I wouldn't have an issue with that. I feel like I could easily defend that.
Now, of course, again, like you said, though, if he's running off, a different story but in that moment, he's still an active armed robber. He is armed. He showed us that he's armed. Even if he puts it back in his pocket or in his waistband or something, I have an imminent deadly threat.
Yeah, this is when people get themselves in trouble when they make a statement, right? Because when the incident happens and this guy leaves and then the police come or whatever, and then now they're shaken up and now there's an interview, right? What happened? Tell me what happened. And the cop might say, so you shot the guy because he was robbing money from the store? Yes, that's why I shot the guy. If you make a statement like that,
trouble
goes to your mens rea, why you shot to protect property.
For those who don't understand the phrase, mens rea means an evil mind, right? Your thought was to protect.
I should probably back up on that. Most criminal, I say most, because we actually have some what we call strict liability crimes that don't have mens rea, which I think is ridiculous, but that's a discussion for a different day. But most crimes have two major components to them. One component is called the actus reus, which is what you did. What did you do? And then there's the mens rea. What were you thinking when you did?
Why did you do it?
Right. And so, this is an important fact maybe in a self-defense case, right? Because if you say, why did you shoot this guy? I shot him because I didn't want the store to be robbed of this money. Well, that's a different statement than why did you shoot him? I shot him because he had already pulled out the handgun once. I was worried he was going to pull it out and shoot me.
Right. He was threatening me with that gun, and so I wanted that threat to stop.
Right. And people should know that, it doesn't give any really more impact to make the statement right there at the scene. The police will like to convince you it does. Well, now's your chance. Now, you've got plenty of chances to make the statement, right? We had a case that we just finished today in court. It's going to be all over the news tonight, as a matter of fact. And we did a press conference today after the case was over. So you can make your statement at any point that you want. Making it at the scene before you got all the evidence, all the information, and you've sort of know everything and consulted with an attorney to get an opinion about the case, especially on an issue as serious as something that could, when you're dealing with a gun, something that could cost you decades of your life. It just doesn't make sense to rattle off a statement right there at the scene. Keep your mouth shut. Talk to a lawyer. You can always make your statement later.
Yeah, you're not going to gain anything substantive. You might feel better in the moment because, oh, look, I'm a good guy and he's treating me like a good guy. But you can say stupid things, and those stupid things can cost you big time later.
I think it's important to note that police officers, this is well recognized, this isn't me speculating or me being biased or anything, but police officers are allowed to lie to you, right? So they can say, this is your only chance to make a statement. They can say, look, I want to present your side to the other side or whatever, or they can even go a little further, and this happens sometimes too, where they go and say, look, we know you're a good guy, we know nothing was done wrong, we just need to get a statement from you so we can close the file and move on. That sounds really appealing to somebody who doesn't want to be charged with a crime. But officers get classes on conducting interrogations, on getting people to talk. I once had a first-degree murder case, and my client was, he was read Miranda, then he was asked if he wanted to make a statement, and he shook his head in a very clear no. And the officer decided that he was confused by the no. And, he started to ask questions. Well, are you trying to say yes? Or are you trying to say, what are you trying to say? I don't understand. And he just could have coaxed him into a big, giant statement later on. And fortunately, I was able to get the entire confession statement suppressed in a first-degree murder where the death penalty was alleged.
Wow.
And so that dramatically changed the landscape of the case. But little subtle things are very important. And police officers are really expert at getting people to talk, and they get to lie to you to get you to talk. They can say, so-and-so's already confessed, so-and-so's already told us you're the guy who did everything. They can make up any of this stuff. And in fact, when they're called on it, officers will get on the stand at the trial and say, yeah, I lied to the guy. And then the follow-up, why did you lie? To try to get him to speak the truth. So it's well recognized in the law that police officers are allowed to lie to citizens. Citizens, of course, are not allowed to lie back to police officers. That could be a crime of giving false information.
So the care there that you want to take is make sure that you talk to your attorney, you've had some opportunity to process things, so in that way the truth comes out. Because of course, if you are shooting somebody over property, that's wrong. We don't want to protect wrongdoers, but we want to protect good people, that what actually happened gets said and not what didn't happen, and you don't get mixed up and get problems.
Yeah,
like
and
that.
keep in mind, whether it's a good shooting or a bad shooting, it's not something we generally know right there at the scene. So it's not really a matter of, well, this is a good guy with a good shooting. We don't know. And so the smarter advice is keep your big mouth shut.
Keep your big mouth shut. Now, I'm going to change the situation a little bit, because again, you don't have any problems defending somebody. Guy put the gun away. Okay, fine. Do get some questions there, not in this particular instance, but we get a lot of multiple attacker armed robberies, and you see a gunman and a grab man. And some folks say, okay, well, wait, I know the gunman is a deadly threat because he's got a gun, he's waving it around or whatever. What about his partner, though? What about that grab man? What are your thoughts on that guy?
Well, I think it's like anything else. I think if you're going to shoot that guy, you got to produce an imminent threat of death or serious physical injury. And so shooting this guy, if he's unarmed and doesn't have anything sort of to threaten somebody with, probably isn't a smart thing to do, right? Probably the guy with the gun is the guy that you ought to be more concerned about. But everything you do with a firearm is going to be analyzed as a separate act. That's it. I mean, you don't, even though the grab guy is as legally responsible for the armed robbery as the other guy, right? Even the getaway driver who never entered the place, he's sitting in the car, he's equally, his criminal liability is equal to the guy that goes in with the gun. Your ability to shoot them is not equal.
Not equal.
So you shoot the guy with the gun because he presents the risk. The guy in the car who's the getaway driver, you don't get to shoot him.
Right. So that may be a great instance that I need to deal with the gunman first, then maybe using that firearm as a compliance tool, either get away from me or whatever, because I just had this serious incident. But you better have a good articulation, and that means a good attorney. So interesting stuff here, and I think, man, so many people get themselves in trouble because they talk too much, too soon, and they don't say the right things to the right people, and because of that, they have problems. So use your force in a judicious manner, use it in a legal and moral manner. I think in self-defense law, the overlap between legal and moral is pretty strong, so use it in a moral manner, and then shut up and talk to your attorney before you make a statement.
Yeah, just as a final note, I think it's important to say that, if you want to carry a firearm, that's fine. If you're not a prohibited possessor and you have a right to carry a gun, but it comes with great responsibility.
Big time.
You're expected to know the law, you're expected to be following the law, and it's not so easy to make split-second, sometimes life and death decisions. Police officers are highly trained, they get it wrong all the time. So it's the kind of decision one ought to take very seriously.
Mm-hmm.
What you're doing is great work. People need to get training. They need to think about scenarios. How would I act in this situation? And if you're not up for that kind of decision making,
Don't carry.
don't carry.
Don't carry a gun. If you're going to choose to carry, you have taken the responsibility of your self-protection. You have also taken the liability of your
It's a
self-protection.
big deal. And the law's not going to be forgiving here. You're going to be held to the letter of the law. So you really ought to know it.
Awesome. Mark, thanks so much.